Hello, everybody. Welcome to the American Dream. Today we have with us two distinguished judges from Lynn District Court. The first justice, Judge Albert Conlon, and his associate, Judge Cathleen Campbell. Both wonderful people, both good judges and very smart, and they have wonderful sense of humor. I don't know if we can bring that out today. It's not the purpose of the show, but you may see it. Judge Conlon is going to receive an award tonight from the Essex Bar Association, the Justice Ronan Award, which is really a great award, and congratulations to you.
Thank you.
And he's shy. He doesn't want to discuss that, so we won't. We recently had Law Day on May 1st, and Judge Campbell spoke at, where did you speak that?
At the Lincoln Thompson Elementary School here in Lynn.
Well, what we do is we provide a speaker to each of the schools in Lynn, including St. Mary's, a judge or a lawyer, and we usually have a pretty good time, and we give out information. How was your session?
I absolutely loved it. The students were wonderful. I spoke to the 5th grades at the school, and they had so many questions for me, and they were so engaging, and it was fabulous to go out in the community like that. It was such a diverse group of students, and it was a wonderful experience for me.
Great.
Very rewarding.
So I want to take the time to thank Superintendent Kathy Latham for allowing us to go into the schools, because we all have a pretty good time, and I think it's rewarding for the kids. And
for us too.
Yeah, and for us too. Oh yeah, it's amazing what people come back with. Every kid wants to know how much money we make, which is interesting.
Well, I'm over my shyness now if you want to talk about the award.
See, good. Okay, let's talk about the administration of justice at Lynn District Court. Give us an overview of the court, civil and criminal. Let's talk about civil first, if you don't mind.
On the civil side of it, well, both the trial courts in the Commonwealth of Massachusetts are the Superior Court and the District Court. And we have courts for probate and family issues and juvenile courts, but the main trial courts in Massachusetts are the Superior Court and the District Court. The significant difference in civil cases is that we have a procedural amount limit of $25,000 at present. I'm on a committee that's seeking to raise that limit, but right now if a case is filed and the damages sought are $25,000 or under, it's filed in the district court.
What's being considered to raise it? To what amount?
We would like to go to $100,000. Right now the target is $50,000, and I think there's trying to make some assessment of how many cases that means we'd capture. What that would add to our caseload.
Is there enough work to go around? Sometimes I have a sense that there's a rivalry between federal court and Superior Court for business. Does that? And we've had this discussion at the Essex Bar.
On the civil side of it, we don't. We have, as you know, we have a very active civil bar and an active civil practice in Lynn District Court. We don't really see competition between us and the Superior Court, and I don't see it playing down between the Superior Court and Federal Court. I mean, that just doesn't impact what we do.
Okay, so you have trials by a single justice, and you have jury trials.
Yeah.
What's the difference?
Well, if somebody makes a claim to a jury trial, then both the plaintiff and the defendant, who's the party being sued, has a right to a jury trial. In the district courts, we have juries of 6. And unlike a criminal trial, where a jury's verdict has to be unanimous, in a civil trial is a valid binding civil verdict as long as 5 of 6 of the jurors agree. And parties always have the right to have the case tried by a judge if they waive the right to a jury trial. But if one party claims right to a jury trial, then both parties have that right.
How many jury trials do you get a year?
That's a good question. About 5 or 6 years ago, when I took over the civil session, I took primary responsibility for it, we were trying between 25 and 30 cases a year, which would be 2 a month or so. Right now, we're down to 8 to 10 a year. and cases are resolving themselves. And part of that's because of the input of the Lynn Bar conciliating our cases.
When you mean resolving themselves, cases are settling?
Cases are settling.
Before trial?
Yeah.
Okay. Is there anything else you want to say about civil?
I mean, what we try to do, I think most practitioners have always found it difficult to get their civil matters heard. And it creates a lot of angst between the attorney and their client, because the client has a suit that he or she wants resolved. So I think the biggest thing we do is we work our hardest so there's an answer to that question, that somebody can be on Wednesdays in the Lynn District Court, civil cases have priority. I don't believe we've had to continue a civil case in close to 2 years now. So we do try to provide a forum where parties can get answers to their questions.
Great. And you do primarily criminal cases, Judge Campbell?
That is true, yes.
Tell us a little bit about how this criminal system works.
The criminal cases originate in the first session at the Lynn District Court. That's when people appear before the court either because they're brought in by the police associated with a serious matter, or they're summoned to come to the first session of the Lynn District Court. For less serious matters such as traffic violations or maybe a possession of a drug case, someone is not brought into court usually by the police. They're summoned to appear on another day. So most of our cases originate in the first session, and people come before the court associated with the matters that bring them before us.
And then they're assigned another date for a pretrial conference?
Yes, that's true. Some matters that are simplistic in nature, for instance, if someone comes in on a municipal ordinance violation, they were drinking in public or something of the like, we'll try to resolve those matters right in the session right away. For cases that are a little bit more complicated in nature, they'll get a further date for a pretrial hearing associated with their matters, and those people come back before the court on another day.
And then they're assigned a trial date?
Beyond the pretrial hearing or pretrial conference date, yes, they will have a jury trial or a bench trial date assigned to them. Sometimes there's an interim date involving the exchange of discovery, which would be called a compliance and election date. So on average, we might see someone 4 times before their case goes to trial.
What's the breakdown between jury trials and trials before a judge in criminal court?
That's interesting. On the criminal side, we do probably in the area of about 65 to 80 criminal jury trials a year. I would say that we probably do more bench trials than we even do jury trials, would you say, or about even? Or
I think it'd be a little less,
less?
the jury waive trials before a judge. I think we do average somewhere between, I suppose, around 80 a year criminal jury trials.
Yeah.
I don't think we get quite that high on the bench trials.
Okay. And as in civil court, there are settlements. I mean, people plea bargain. That's equivalent to a settlement in civil court, right?
They do. I think one of the hardest concepts for people to understand, though, is if they end up being the victim of a crime, that it's the state that controls that process. Sometimes people think that they can come before the court and have settled their differences on their own, and sometimes they can do that through what's called kind of an accord and satisfaction.
Right.
But in the majority of cases, those are controlled by the district attorney's office, and they're the ones that will continue prosecuting those matters if they think it's in the interest of justice, even if a victim came before the court and said, I want things to end at this particular point. I think that's kind of a little bit of a difficult concept sometimes for people to understand.
Right. Listen, let's talk about bail. Serious matter right now. And there are some stories out there that bail is being unfairly imposed on defendants. Who wants to address that? Both of you?
Well, I'll start. I think there are 2 concepts that you do have to discuss. When it's simply a question of bail, the purpose of bail is to make sure that a party or a defendant appears when he or she is required to appear.
That's the basic purpose
That is
of
the
bail.
basic premise of bail, and the presumption under the statute is that someone's going to be released on personal recognizance unless that wouldn't be sufficient to ensure their appearance.
That means without bail.
Without bail.
Yeah.
And, you know, there are concepts, but what we're really looking for roots or ties to the community that would assure that someone will answer to the charges at that time. And there's a laundry list of things that we take into consideration, including prior records, records of defaults, whether or not the person's been successful on probation, whether or not the person has restraining orders against him or her, whether or not there are cases already pending or probation violation pending. So there's a laundry list of really elements that we look at in determining the amount of bail. The second piece to that, and there may be some confusion in the public, is for certain enumerated offenses, the district attorney can move to have someone held without bail, which means they're incarcerated on that once they're found to be dangerous. And the person's automatically held, or close to automatically held, for 3 days before that hearing can take place.
That's irrespective of the crime being charged?
If there's, under the dangerousness statute, there are specific enumerated offenses that the district attorney's office can move for dangerous.
What are some of those offenses?
Oh, they're the most significant offenses: assault and battery with dangerous weapons, your domestic violence, your third time operating under the influence.
By the way, you have a limit on how much time you can give somebody to serve in jail. Is that right?
Yeah, that's a good question. What distinguishes cases being brought in the district court and superior court largely are the district court only can sentence to the House of Correction, and there's a 2.5-year maximum. If a case is significantly serious and the Commonwealth's considering state prison time, that case would be brought to the superior court.
Okay. So what about bail? That's a big issue before the community right now, and I know there's some misinformation about it. You've just given the basics of bail.
There is some misapprehension, and I think one of the people where the judges that sit in Lynn do a very good job is considering the resources of the community. If you set a bail in the amount of $750, that's a significant amount for a large part of our community. Yeah. And that may not be shocking in the newspaper, whether you're pro or con with that amount being set. But that's a significant number to a large part of our population. I don't get the sense that there's an issue of bail in our court. I think it's set fairly.
I think some of the misunderstanding relates to international cases where people expected to be sent back to their home country because they're not legally, they don't have legal papers to be in the United States.
Well, under the statute, one of the things we do consider are roots and ties to the community, because that's essentially what is probably the strongest indication that someone will appear.
So, in other words, if somebody came here when they were 10 years old and they never got their citizenship and they don't have a legal basis to be here, they don't have a green card, but they've been good, solid citizens, you'd consider that?
Oh, I mean, to me, it's more duration duration in the community than really necessarily what brings you here. I mean, if you have families here, then the other is really an ancillary consideration, because we can address that.
So the feds, is it ICE?
Yes.
They have what's called a detainer program?
Yes.
How does that work?
Well, I think every court's wrestling with that now. We have no obligation, or very limited obligation, to hold someone pending the service of an ICE detainer. We're routinely told that ICE is seeking a detainer, but we're dealing with what's before us, and if there's no hold before us, then we address the cases before us.
So how does ICE know that there's somebody in your court that should be detained because of their
I'm sure it's law enforcement communication before it gets to us, because we're given that information, by our court officers, our security staff.
But your court doesn't notify ICE?
No.
So you think it might be police?
Well, I'm sure it's law enforcement upon arrest. I'm sure there's...
Okay. And so they say, you arrested, I mean, you got John Jones before your court. We want you to hold him. What will you do?
I think there's protocols coming down now, because we're all dealing with it.
Right.
Where we can notify ICE that we have somebody and that person's going to be released in X amount of time if ICE doesn't get there. But we're not going to hold people overnight or an extended period of time for ICE to take action.
Okay.
And quite frankly, if they're aware that there's a case, or there's a person in our court with that detainer, they shouldn't be waiting around to see what we're going to do. I mean, they can be proactive and appear.
Yeah. Okay. So you're a busy court, about the 4th or 5th busiest court in the Commonwealth?
I think we're generally 4th, 5th, or 6th in any given year, but we're significantly busy.
Yeah. What does a first justice do?
Is she listening? It's funny, the administration of the court department isn't what it might appear to the outside. The clerk's office is really a separate entity. The clerk's appointed by a governor. The clerk runs, in our case, her office.
We're going to try to have the clerk on next.
Yeah, and she does a terrific job.
Yeah.
Probation is run by the Commissioner of Probations in Boston, and we have a local fellow, Joe Panucci, that's terrific. He grew up in Lynn. Our security staff is run by John Nerrick, and there's a separate security department.
And Justice Campbell runs the court. So what is it that they...
Yeah, sure, which is what it is I do. I pretty much know what room to sit in on a given day. We're told in this case law that says that we're in charge of the overall maintenance of the building, but
I didn't
simply
realize I
have
was
no
going to put you
authority.
on the spot.
No,
No.
you don't have a lot of statutory authority.
Yeah. Well, you do most of the civil cases, don't you? Don't you preside over
I
most
do
of those
them
cases?
now because of the input of the Lynn Bar. I want to make sure that
Yeah.
we respond to them because they've been so helpful to us.
Yeah. Well, that's
But
great. I mean, that's a great program. Let's
Oh,
face
it's
it.
terrific.
You know,
And in fact, I'm on a statewide committee, and I'm only on the statewide committee because our court looks so good, and our court only looks so good because of the Lynn Bar.
we used to have to wait 7 years to get a civil case heard before a judge or a jury. And Judge Funari and Bruce Satcher put together this great program, and it's worked out very well. Now you can get a trial within 7 months. Is that
Oh, sure.
fair? Yeah.
Yeah.
That really is amazing, because before I came to Lynn, I traveled around to a variety of different courts in the Commonwealth of Massachusetts, and it was standard elsewhere where I would sit for a civil case that was coming up for trial to be 2.5, 3.5 years old, sometimes even a little bit older. So the fact that they moved the civil docket so swiftly here in Lynn is just amazing, and that's why they have Judge Conlon on that committee, because they're
Right.
hoping to replicate it elsewhere in the state.
I'm glad we're talking about this. As you know, my wife, Attorney Ann Gagino Carrigan, she calls the cases for this
conciliation,
process. And she has talked with other courts, and I won't mention their names, from around the Commonwealth. They want to know how is it working in Lynn, and she's talked with them, and they don't seem to adopt it, and it just...
Well, I think I sound like a broken drum when I go to the meetings. We're only successful because of the input of Lynn Bar.
And it's so easy to do.
Well, you have to reach out to people with their primarily civil practices that want
Right.
to volunteer
Right.
some time, and then you can
Yeah.
start working with what fits for everybody. But without the input of the local bar, our program can't be replicated.
Okay. So let's talk about sexual abuse. It's a national problem, it's an international problem, and it's a problem in Lynn, and we can only talk about Lynn. We've done some work on this problem over the last year or so. We had a training session for people who I'm in a position to teach kids, supervise kids. Brigitte Damon from Lynn Economic Opportunity oversaw this whole thing. We brought in an expert from Boston who was really quite good. We had her on the show earlier this year. And we brought in Kate McDougall, the
Sure.
Assistant District Attorney, who's in charge of the sexual abuse unit for the DA's office.
In the Superior Court, yes.
In the Superior Court, yeah, and she spoke to our group, and we had who else did we have? We had Lieutenant Marie Hanlon also spoke to our group, and she's excellent, cooperates with everybody. She's in charge of the sexual abuse unit in Lynn. So there's prosecution, there's treatment, and there's prevention. And we think the prosecution is hard because victims don't report it. I mean, that's the number one reason. They don't report it. They're afraid, they're embarrassed, they're ashamed, they don't know what to do. And treatment is generally good. I mean, we also had, as part of that program, Dr. Mark Alexikos, who heads up the mental health unit from Lynn Community Health Center. And they do a terrific job. But that's treatment. I mean, because the effects of the sexual abuse, I've interviewed dozens and dozens of women over the last several years, and some men. It happens to men also, but mostly women. And they get post-traumatic stress disorder, depression, anxiety, agoraphobia. They have nightmares, they have flashbacks, they sweat. They're afraid to leave the house. They stay in bed all day, and it's unbelievable what happens to these women. And it all started, for most of them, when they were about 4 or 5 years old. And they didn't tell their mothers, and they didn't. Sometimes they might tell a teacher or something, but for the most part, they don't tell anybody. And they repress it for a number of years. And then something happens in their life that brings it all back. And that's when all these symptoms. So it might have started at 4 or 5 years old. Now women's 35, 45, 55, and she's suffering these horrible symptoms. And so it occurs to me, and we talked about this last year, we're going to talk about it again, prevention is the way to go. But how do you tell a 4-year-old kid, you know, to defend herself against a man or an older boy? Judge Deva, before he retired, or after he retired, told me that during his 17 years on the bench, he concluded at the end of that the most unsafe place in the world for a child is the home. So, and I obviously believe her because I see it all the time. I see the victims all the time. So one of the things I would like to do today is ask people, if you have any ideas about how to prevent it, send me a letter. Send it to the American Dream, P.O. Box 2163 in Lynn, Mass. And I'll bring it back to the people that I've been working with, and we'll see if we can improve. One of the things that happens is a woman has a boyfriend, and you can't trust the boyfriend. And the woman leaves the boyfriend babysitting, and he takes advantage of the child. Or at other times. I mean, it happens mainly in the home, from husbands, boyfriends, grandfathers, cousins, landlords. I mean, you know, just. So I would caution everybody to really watch your children, the children in your household. So the punishment is there, but it's hard to get. I mean, I know we talked with the District Attorney Blodgett about this issue, and it's hard to get kids to cooperate, or their parents. There's shame involved with this, even though you're a victim. I mean, when I first decided to do this, I started talking to people, and they'd look away, like, I don't want to talk about sex. Seriously. Normal, together adults, they don't want to hear about it. But we have to address it. It's just killing people. I mean, they except that they don't die.
I'll let Judge Campbell address this, but I would just say at the outset, the court's in a different position, somewhat, because in these situations, we're really reactive. These things only come to us once a complaint or charge has been brought. And the second thing I would say is that they're tremendously difficult prosecutorial decisions. Judge Campbell mentioned at the outset that some people don't understand that the case belongs to the Commonwealth. In this area, this is the one area most significantly where the Commonwealth will listen to the positions of the victims and the family and be guided
Yeah,
a
good.
lot in that area because of the difficulty of testifying, the shame, embarrassment. But I'm sure Judge Campbell wants to weigh in on this.
Yeah, T.A. Blodgett has a good unit set up to deal with exactly that.
He has a fabulous unit. I would just mention a couple of things, though. I think that it's incredibly important for parents to talk to their children about these situations, because while the majority of these situations do occur in the home, many children go to child care because their parents are working. And I think it's really important that even when a child is at a very young age, parents talk to them about what could happen, and also use very clear terms in terms of discussing anonymical parts, so that if a child were touched in an inappropriate fashion, they would know how to communicate that back to their parents. I would just note that it is such an issue, because when I was in private practice, probably 85% of the women that I dealt with who had substance abuse problems had been sexually assaulted.
And they go hand in hand.
And they
First
do.
came the sexual assault, then came, that's what I believe.
And so it's so important for people to be able to talk about these things, but that really begins with education within the home and parents not being afraid to discuss things with their children, so that they know that if something happened to them, they could come to them or another trusting adult right away.
That's great. We're going to have to wrap this up. If you have any questions or concerns about this, Brigitte Damon at Lynn Economic Opportunity would be happy to talk to you. She learned the training, and she's now training others in the community. So thank you very much for coming on.
Thank
Yeah,
you.
I appreciate it.
Thank
Thanks.
you.